Hello, this is Taylor from Sprintlaw. May I please speak with Alex?
Yeah, that's me.
Great, thank you, Alex. I'm calling to assist you with your questions about commercial contracts and the meanings of specific clauses under Australian law. Could you please specify which clauses or areas of the contract you need help understanding?
Yeah, so I've just been given a contract to sign. Uh, it's actually an adjusted version of my contract. I'm a software company. I shared it with a client. Their lawyers got involved, and they're wanting to change my indemnity clause to make me promise to warrant that I'm not infringing any third-party intellectual property or something like that, and I got to indemnify them. What does all that mean? Is it normal, and should I accept this clause?
The indemnity clause you're referring to is quite common in commercial contracts, especially in industries like software development. This clause essentially requires you to compensate the client if they suffer any losses or damages because your software infringes on a third party's intellectual property rights. Accepting this clause depends on several factors. One, risk assessment. Consider the likelihood of your software infringing on third party intellectual property. If you use open source components or have developed everything from scratch, this risk might vary. Two, insurance. Check if you have professional indemnity insurance that covers such claims. This can mitigate potential financial impacts. Three, negotiation. Now, you might negotiate the scope of the indemnity, perhaps limiting it to claims proven in court or adjusting the financial limit of your liability. It's crucial to weigh the risks and protections before agreeing to such a clause. Would you like to discuss how you might negotiate this clause, or is there another aspect of the contract you need clarity on?
Yeah, just negotiating it is what I'm really interested in. Like, what should I go back and say to them? Can you tell me what I should ask for?
When negotiating an indemnity clause, particularly in a software contract, you can consider several strategies to balance the risks and protect your interests. One, propose limiting the indemnity to only cover claims where it has been judicially determined that your software infringes on third party intellectual property rights. This prevents you from being liable for unfounded claims. Two, cap the liability. Suggest capping the amount you're liable to pay under the indemnity clause. This cap could be a specific monetary amount or tied to the contract value, such as not exceeding the total fees paid by the client.
Okay, yeah, I get it. Can you just tell
Reciprocal
t- tell me
indemnity.
tell me exactly what I should say? Just pick an option and that you think is right, and just tell me what to do.
Certainly, Alex. A practical approach could be to limit the scope of the indemnity. You might say something like this to your client: I've reviewed the proposed changes to the indemnity clause and I understand the concerns regarding intellectual property rights. To ensure that both parties are protected fairly, I propose that the indemnity only applies where there has been a final judicial determination that the software infringes third party intellectual property rights. This adjustment ensures that the indemnity is invoked based on substantiated claims, providing security for both parties involved. This approach focuses on protecting you from potential unfounded claims while still providing your client with assurance against legitimate intellectual property infringement issues. Would you like more assistance on how to handle this negotiation, or is there anything else you need help with regarding the contract?
Could I get them to like warrant that? You know, like I don't want to be liable if they're the ones infringing intellectual property, and then there's a third party claim. Isn't that a legitimate concern? And another way I could adjust the clause.
Yes, that's a legitimate concern and a sensible approach to further protect yourself in the contract. You can request a reciprocal indemnity or a warranty from the client to ensure that you are not held liable if the infringement arises from their specific requirements, misuse of the software, or modifications they make. You might propose adding language to the contract, such as, I propose adding a clause where you warrant that any specifications, requirements, or modifications you provide or make will not infringe on any third party intellectual property rights. Additionally, should there be an infringement claim arising from your provided specifications, requirements, or modifications, you would indemnify us against such claims. This adjustment ensures that both parties share the responsibility for preventing intellectual property infringement, and it protects you from liability arising from the client's actions. Would you like to explore this option further, or do you have any other aspects of the contract you'd like to discuss?
And no, that's all. Thanks.
You're welcome, Alex. If If you have any more questions in the future or need further assistance, feel free to reach out. Have a great day and good luck with your contract negotiations.
Thanks.